Welcome to our second lecture covering the topic of terminating individual employees. During our first lecture, we covered the first three topics, determining whether a termination has even occurred. In other words, is this a situation where there's a constructive discharge, an actual termination that the employer has um, accomplished, or a resignation? Then we talked about employment at will and the exceptions to that briefly. And we discussed some impermissible grounds for termination, again, very briefly. Those are both topics that we've covered kind of ad nauseum throughout the course. And now we're going to fast forward to slide 32 and begin our final two topics. And those last two topics are going to be just cause, also sometimes called due process, and also how to handle terminations. Many times, legal professionals will be called in to conduct terminations. I know in my career, I have discharged many people that were kind of considered delicate situations. And then there would be other times where you might advise people who are actually going to do the dismissal how to accomplish it. Much of this section is probably going to feel like common sense to you, but when emotions are running high, sometimes common sense is a little bit uncommon. And so it's always a good idea to remind people of things that they know, that their better spirits know, but they may not be fully experiencing at that particular moment. So let's begin with a discussion of just cause. I have this in the category of unionized employees, but it's not just unionized employees. There are really kind of three categories of, or actually four categories of folks who we need to look at from a just cause perspective. Of course, one is the union situation where the employee is part of a bargaining unit, and that bargaining unit, the union and the employer has negotiated a contract for. Another, we can see a just cause approach applying in government employment. This can be both state and federal government employment. Of course, if you reside in Montana, that can also be because Montana has a particular statute that basically replaced at-will employment with a just cause system. And then finally, of course, an individual might have a individual employment contract, and those terms of employment oftentimes include a just cause provision. So I say that just cause applies in these four situations, but that's not completely true. For example, there are definitely employees who work for the government who are not under a just cause status. There's also not very many, but a few union contracts that have it that are still the employees are not under a just cause uh, regime. Those are rare, but it's certainly conceptually possible. You can have a union contract and not have a just cause standard. And you definitely can have an independent contract where it's just an individual employee who's negotiated a contract with his or her employer where there is not a just cause standard. So usually these four situations have a just cause standard applying to them, but it's not inevitable. And of course, the secret to this is look at the contract and or look at the statute that applies in those circumstances. But there's another way that we don't want to limit just cause to these four situations, because even when we're talking about an at-will employee, which is going to be the vast majority of employees in the state of Texas, certainly 90% or more, even with respect to those folks, even though they are employed at will and there is not a legal requirement that we use a just cause standard, it certainly makes sense in the vast majority of cases to use a just cause standard. Now, we may be in a situation where there is an economic need for a layoff, and that, of course, we're not going to be looking at a just cause standard. But if we're not looking at that situation, employers usually apply an informal just cause standard to terminations, even of their at-will employees. And you may be saying, well, why? Well, there's several reasons. I mean, one is just common sense. Why would you fire somebody unless you've got a good reason to fire them? I mean, firing somebody means you now have to replace them. So you're going to have to go to the hassle of finding somebody and training that person, and that person may not be as good as the person that you previously had. Plus, randomly firing people is really bad for morale. And some of your best workers are going to say, I don't want to put up with this. I don't want this sort of Damocles over my head all the time. I want to go to work in a place where I feel like I'm valued and that I have, some security. And so, for productivity reasons, for cost reasons, for morale reasons, all those reasons, just cause makes sense. But there's another reason that employers use just cause, and that is that if you fire people randomly, the assumption that jurors and sometimes judges will make is that it really wasn't random. That you were really firing Bob not because he wore a green tie to work, which is the reason you gave, but because he's African American. Or the reason that you fired Bob wasn't that he showed up 30 seconds late to work after 5 years of employment, but that he happens to be Hindu. The jury will assume there is a reason, uh, but probably an unlawful reason if the employer isn't providing a reason that makes kind of common sense. So it's not required, but if you don't have one, just be aware that the jury is going to assume that if there isn't a reason provided or the reason is silly, that that's not the true reason. So for that reason, for those reasons, even in an at-will situation, employers are wise to apply a just cause standard. Now, just cause in the union context is a pretty tough one. I have been involved in many cases where an employee clearly deserved to be fired, should have been fired probably 10 times earlier, and yet the arbitrator sometimes will reinstate that employee. That's not the kind of standard that I'm talking about for with respect to at-will employment. It isn't a standard where, gosh, every single possible benefit of the doubt is given to the employee, and every single time that the employer slightly didn't follow its procedures, an evil motive is assumed to that. So if you have worked in a situation where you do have a union contract and that just cause standard really becomes, boy, the employer has to jump through 50 hoops to dismiss somebody. That's not what I'm suggesting when we're talking about just cause in the at-will situation. What we're looking for is, did the employer, actually, let me look at it here. I've got it on a slide coming up here. Go forward. Was there a reasonable standard? Was there a rule that the employee did not follow? Now, sometimes the rule is just common sense. You don't need a rule if you're not talking about a union contract, but you're talking about an at-will employee. You don't need a rule that says don't steal from us. You don't need a rule that says don't watch porn on your office computer. So sometimes it's just a common sense thing that, anyone that has to be told not to do that doesn't need to be working here, basically. Did the employer clearly communicate the rule? Again, if it's a rule that would benefit from clear communication. Is the rule reasonable? Did the employer consistently apply the rule? In other words, every time somebody did what this employee did, was that person fired? And if that person wasn't fired, was there a very good reason? Maybe that person had very long service. Maybe that there was extenuating circumstance. They violated a safety rule, but the reason they violated it was to, save somebody who was in a situation involving jeopardy. Did the employee have a process of some kind of due process? In other words, did the employee have the opportunity to present his or her own evidence? Did the employee have the opportunity to make an argument explaining why he or she did what he or she did? Is there enough proof? What is the level of proof? It's not beyond a reasonable doubt, or at least it shouldn't be in the at-will situation. But is there, a significant amount of evidence that points to the employee having broken the rule? Did the employer use progressive discipline? Meaning, if it's not one of those situations where the violation is just really, really serious, like theft, did the employer counsel the employee several times before termination? And many times we see a 3-tier system. A first warning, which is oftentimes called a verbal warning, although it's usually documented in writing. and then a written warning. And sometimes there's going to be a final warning, and then there's dismissal. So it can be that these two are combined into one step, but 3 or 4 steps. Now, again, there's no expectation of progressive discipline if somebody did something like, get into a fight or steal something or do something, kind of very, very serious. But if it's something like showing up late to work or not complying with the dress code or not being sufficiently productive at work, those types of situations is where you would see the progressive discipline. Was the discipline commiserate with the offense? Were they reasonable responses to each other? In other words, if I'm 30 seconds late, I shouldn't be fired for it, even if it's a progressive discipline situation and I've been warned twice before because I was 30 seconds late. That doesn't feel reasonable to us, except if there's some reason why in this particular industry you really have to be there on time. So these are examples of factors that you would think about as you consider whether there is, sorry, I went too far, whether there is just cause to dismiss. As we saw, sometimes due process is an alternative name for the just cause standard. And here, just cause, we're looking at the reason. Why was this person fired? But it's usually not just the reason that matters. It's also, did the way that this decision to dismiss was reached, was it fair? For example, if I am the boss and Bob and Larry get into a fight, but I only interview Larry and Larry tells me Bob provoked the situation. He punched me, he called me awful names, then he punched me, and I was just defending myself. And I, the manager, only speak to Larry, and I decide, well, I'm going to fire Bob, but I don't speak to any other witnesses. I don't speak to Bob. I don't review Larry's personnel file or Bob's personnel file. Uh, Under those circumstances, I haven't given Bob due process. But let's say that, no, I do. There were 3 other people who were present, and I interview each one of those individuals. I interview Larry. I interview Bob. I get information about their injuries. It ends up, we'll say that Larry was significantly more injured than Bob, and the degree of his injuries seemed excessive, given the degree of Bob's injuries. So it wasn't strictly a matter of just pure self-defense. The 3 witnesses, 2 of them were strongly in Larry's camp. Larry was obviously strongly in Larry's camp. And the witness was kind of, the 3rd witness wasn't kind of in either one of the camps, but everyone agreed that Bob was certainly hitting Larry more times than was necessary to stop Larry from hitting him. Bob has been in 2 previous situations where he's had kind of disagreements with coworkers that got at least a little physical, and he had been given progressive discipline about those issues. Bob's only been employed by the company for a year. Under those circumstances, it looks pretty clear that we've given Bob due process because we've interviewed him and interviewed all the other witnesses. And it looks like dismissal under these fact patterns is reasonable. We have a just cause reason for dismissal given the totality of those circumstances. So you can call it a just cause standard or a due process standard, whichever term you prefer. But at the end of the day, you need to look at the reason and the process to decide whether it was a fair system. So again, the way when we're looking at unionized employees, the way we decide what the standard is we literally look at the contract language, just like we would any other kind of contract dispute. A labor contract is for the most part just a contract, and it explains what both the employer is supposed to do and what the employee is supposed to do. And in the case of a labor contract, what the union is supposed to do. And it defines that relationship and the expectations. It also says what the employer is entitled to expect from its employees and what the employee is entitled to expect from the employer and from the union. So it's designed to define the relationship and the expectations. And if it's well written, it's going to help avoid conflict because everybody knows kind of what their role is in that situation. Well, the vast majority of union contracts provide that Dismissal, or really usually any discipline, will need to be on a just cause basis. It's not an essential part of the union contract. You can have one that doesn't have that, but the vast majority do. And typically there is a step process, a grievance process that the union and the employer will go through to resolve one of these disputes. So let's say that Bob is dismissed for getting into a fight with Larry. Well, he files a grievance, and then typically there's going to be a process such that the union steward, the representative of the union, who is also an employee typically, is going to meet with somebody in management and present Bob's argument that the dismissal ought to be overturned. And there will be some discussions between the union steward and the manager. If that resolves it, great, we're done. If not, then there will probably be some next step where a higher level person within the organization reviews the matter. And eventually it will get to the point that, let's assume, it can't get resolved. So eventually it will go to some kind of arbitration process. And that arbitration process will involve uh, people from outside of the organization, typically an arbitrator who has no particular ties with the union or with the employer, kind of a neutral party, who's hired to handle this particular matter. Now, some employers like to use systems like peer review. When I was in private practice, that was the system that we used in industrial settings, where there would be a group of, I think it was 5 employees who would uh, sit on a panel to decide whether to reinstate an employee or not. And those employees would um, hear the evidence that both sides wanted to present, that the company wanted to present, and that the employee wanted to present, and they could decide to reinstate, to not reinstate, to award back pay, to not award back pay. Anyway, so that's that peer review can be used in union situations, but it's typically not. It's typically something that non-unionized facilities do, kind of in lieu of a arbitration type system. But if it does go to arbitration, if you do have a unionized situation, or you can even have arbitration in situations where there isn't a union, the arbitrator typically has broad authority. He or she can decide to reinstate the person or not reinstate the person. He can decide to award some back pay or not award some back pay, depending upon his or her interpretation of the facts of the case, the just cause standard, and in the case of a union, what the union contract provides for. Let me just show you an example of a union contract. I pulled one up. This is a Teamster one. This is an example of the discipline. The employer will discipline employees for just cause only. Disciplinary action will be in the form of, and here are the 4 examples: oral reprimand, written reprimand, suspension without pay, or discharge. So you can see the just cause standard. We won't go through all the process that this contract provides. You can see this contract is literally 100 pages long. It's not unusual for contracts to be 200 or more pages long. These are not short documents usually. We've already kind of gone over these things. So just the same way that the employer looks at a decision and tries to decide, is this the right decision for us to make? Should we dismiss? The arbitrator is going to be engaged in that same type of analysis. Arbitrators are interesting individuals. They have a variety of backgrounds. Most of them are attorneys. Some of them are former judges. Many of them, especially who do labor work, have been labor attorneys. One of the things that they do to market themselves is they want to, or typically the way arbitrators are selected is that there will be a panel, often 5, sometimes 7 arbitrators will be on the panel, and the union and the employer get to knock people off. So let's say there were 5 people. I'll just list 5. I'm just going to give them letters. So we have A, B, C, D, and E. And these are kind of randomly selected from the pool of qualified arbitrators. Well, let's say the union gets to eliminate one first. Well, the union eliminates C. Now, why does the union eliminate C? Well, in the union's opinion, based upon reviewing C's published arbitrator awards, the union thinks that C would be less likely to rule on the side of the employee. And so it would make sense for the union to want to eliminate C. Well, the employer then gets to eliminate someone, and the employer eliminates A. Essentially because the employer thinks, based upon the arbitration awards that this arbitrator has made, that the arbitrator would be less likely to rule in the employer's favor. And then we'll say the union eliminates E and the employer eliminates D. So B is the last one standing, so to speak. Now, all the arbitrators understand that this is the system that's used. So you don't want to be an arbitrator that is closely aligned with either the union side or closely aligned with the employer side, because that means if that's the way your awards routinely read, that means that it's very likely that one or the other is going to remove you from the panel. You want to be that middle of the road person. And as a result, you tend to get somebody who is, I'm going to call a baby splitter. For those of y'all that aren't of the Christian tradition, there's a story in the first half of the Bible in the Old Testament, also the Jewish scriptures, where Solomon was presented with, Solomon was a very wise king, and he had two women came before him uh, trying to resolve a dispute that they had. And apparently they lived together, and they had a disagreement as to who was the mother of a particular child. And they both claimed that this was their child. And then Solomon said, well, let's just cut the baby in half, and you can have one half and you can have the other half. Well, the true mother jumped up and said, no, I'd prefer that this lady have the baby. I don't want to cut my baby in half. And the other one, who wasn't the true mother, says, yeah, go ahead and cut the baby in half. Anyway, so he decides to give the whole baby unharmed to the mother who didn't want the baby cut in half. Anyway, so that's the idea. We don't, our culture doesn't like the idea of baby splitters, but arbitrators do like it. They like to give both sides a little bit of something, because again, it makes them seem middle of the road. So it's not unusual in an arbitration situation in labor, or really any area of the law, to find arbitrators kind of looking for a middle place between the two. The union wants reinstatement with complete back pay. The employer wants no reinstatement, no back pay. So what the arbitrator is probably looking for is something in the middle. Maybe reinstatement, but no back pay, for example, or throwing something towards the union, but not giving the union everything, but giving the employer something that the employer is going to like. That's kind of the sweet spot. If you have a lot of rulings like that, you end up being an arbitrator who can get a fair number of assignments, and that's how you earn your money, right? So you're interested. You don't want to be the first one eliminated. That's not a good spot. So gives you a little bit of information about the dynamics of arbitration. Okay, we've already talked about grievance process and grievance procedures and due process. Progressive discipline. Again, you'll have the first violations, a warning or some other mild discipline. Then it becomes more severe. There'll be steps. There could be one step or multiple steps here. There could be some type of unpaid suspension that gets in the mix here. And then there can be dismissal at the end. Okay, so now we're going to flip and talk about public sector employees. We've talked about this in the past, so I'm not going to spend a ton of time on this. But for the most part, public employees are not employed at will, especially not after they've been employed for a significant period of time. As a result, a just cause standard typically applies to them. There are civil service laws in many states and tenure laws, that especially applies to school teachers, that give them job protection. And of course, we have constitutional protections. We have the Fifth and the 14th Amendment provide due process protections. The 14th Amendment's the more important. And then, of course, our First Amendment gives us protections of freedom of speech and religion and association. And this is important because if we're being dismissed for things that we said or what we believe or who we associate with, and our employer is the government, then that, of course, can be a violation of the Constitution. Now, this won't, of course, apply if I'm working for a private entity, Walmart or Exxon or something along those lines, but just when I'm involved in government work. Let's pause here and just look at those constitutional protections. So here's the 14th Amendment. The 14th Amendment is a really long amendment. It was passed right after the Civil War, so it's one of those Reconstruction era amendments, and it has lots of importance, uh, both from who's a citizen of our country to how jurisdiction works in our court system. But the part that we care about right now is this one, the due process section. Nor shall any state deprive any person of life, liberty, or property without due process of law. Let me go to the First Amendment, which you probably also heard about, which is much shorter. Congress shall make no law respecting an establishment of religion, and here we're getting to the more important part, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of people peaceably to assemble. And so if there's somebody, maybe I'm a state or federal employee who writes a letter to the editor of the newspaper, it gets published, and my boss doesn't like it and wants to fire me for it, then that would be an instance where my right of freedom of speech is being curtailed. Now, if I work for Walmart, I don't have any protections for this. It's only when I work for some state or federal or local government entity that I have protections. We do in Texas have a tenure law. The goal of the tenure law is to create an environment where educators are free to raise questions, to express controversial idea, and to pursue knowledge and truth without a lot of limitations. And this, of course, applies to both public school teachers and professors who work for public schools and universities. Now, it doesn't apply to private school teachers or private professors because obviously those are not government entities, and so a state law isn't going to limit, the actions of a private entity. But most of the time, especially if it's a college, those professors are going to have some type of tenure system in place. This is the tenure protection that we have in Texas for public school teachers. Let me just pull it up here. And we have right here the language. A probationary contract may not be for a term exceeding 1 school year. The probationary contract may be renewed for 2 additional 1-year periods for a maximum permissible probationary contract period of 3 school years, except that the probationary period may not exceed 1 year for a person who's been employed as a teacher in public education for at least 5 of the 8 years preceding employment by the district. So that's kind of when, after the 3-year point of employment with a particular district, a district has limited ability to dismiss an employee, it's not an employee, a teacher, other employees they can dismiss, but a teacher, unless there is that just cause. So if I'm a tenured, 4th grade teacher, for example, and my principal and I just don't like each other, and my principal wants to fire me but doesn't have a legal basis, she's going to be out of luck. If I don't have my tenure, then the principal would have probably a little bit easier time firing me. Now, probably most school districts would not permit the principal to fire without having a good reason, but in theory, legally, the employer could dismiss. Now, even when a teacher isn't tenured, typically a teacher is in a 1-year contract. And so the principal would unlikely be able to dismiss during the course of that contract, but may not renew the contract. So let's say again that I'm in my I've been teaching at this elementary school for last year and a half. My principal and I do not get along. Well, my principal may say, I'm not renewing your contract for a third year. You'll complete this year and then we'll be done with you. And under those circumstances, since I'm not tenured, I probably don't have a legal basis. Unless, of course, I think that my teacher, or excuse me, my principal isn't renewing my contract because of my race or my religion or my gender or my age or one of those legally protected reasons. So we're talking about, again, government employment, and public employees can have a property interest in their job. Remember we talked about life, liberty, and property? Let me just flip back here to the 14th Amendment. Life, liberty, or property. So you can have a liberty interest in your job or a property interest in your job under the 14th Amendment. And so a property interest, and this is a definition, you may not have this in the version that you see online. I did add this. And again, I would encourage you to add this to your Quizlet. So a property interest arises only when the person has a legitimate expectation of continued employment based upon a legitimate claim of entitlement. And here we have liberty interest. An employee's liberty interest can be threatened when a public employer makes allegations against the employee that are damaging to the employee's reputation for honesty or morality. That's what a liberty interest. To me, this definition isn't very intuitive. This one makes sense to me, at least, but this one doesn't. So you may want to put a double check mark by this one because it's a little bit less obvious. So public employers owe their employees due process both before and after termination. And prior to termination, the public employer needs to give that employee information about what the allegation is and an opportunity to present their side of that. After the termination, then there needs to be additional process involved. Obviously, the circumstances of why the person's being dismissed and the totality of those circumstances can vary. You may have seen cases in the news where an employee is put on suspension while this matter is being resolved. And oftentimes that's because of all of this due process that the employer, the public employer, may need to provide the various steps. Sometimes the situation may be like, I can't believe that person hasn't already been fired after what they did. Well, again, that process needs to be followed, even if it appears to an outsider that it's obvious what should be done. We need to have that process in place. Probably will be the case that the employee isn't continuing to work, but there needs to be that process so that the matter can be resolved. And sometimes facts that are reported in the news may not be exactly right. Maybe the facts are quite a bit more complicated, or the facts aren't as certain as what is implied initially. Let's see. So let's talk a little bit more about the First Amendment protections. So if I am writing to the newspaper or posting something on Facebook, and I'm posting it just as a citizen. For example, let's say I am voting for Bob for president, but my boss really supports Larry for president. And I start posting on Facebook, I'm going to vote for Bob. I think Bob's the best president that we could ever have. I really like Bob's perspective on these issues. I really think Larry is not good on this issue or that issue. And so let's say that my boss finds out that I'm making these posts, and he wants to fire me for that reason. Well, I'm certainly posting that stuff as a citizen. I'm not posting it as an employee. And so that would be inappropriate. But let me switch things up. Let's say that I'm a police officer and I start posting. Let's say the chief of police has a new policy that says that police officers are not permitted to drink coffee while they're on duty. And so I start posting on Facebook, I can't believe I'm not allowed to drink coffee while I'm on duty. I sometimes have to work the night shift and I'm really tired, and the coffee helps keep me awake and it makes me safer because I'm having to drive, and you don't want somebody who's sleepy driving. And so this is a dumb policy. It's making things more dangerous. It's making the lives of the police officers less good. And so I think this policy ought to change. Well, I'm really speaking as an employee, not as a citizen, because I want that policy to change because I don't like it in my status as an employee. That speech is not protected from termination. It's only when I'm speaking about matters of public concern. So it is important to think through those differences. And this is kind of an overview of how a terminated employee would have to advance her claims if she feels that she was dismissed for using or exercising her First Amendment rights. So she'd have to go that she'd have to present evidence that she was engaged in constitutionally protected speech. Again, the speech concerned a matter of public concern. She was engaged as a citizen, and when balanced against legitimate interests of the government agency, the speech was not unduly detrimental or disruptive. And she would have to prove that the government agency disciplined or discharged her for engaging in that speech, and that finally there was not an overriding justification for the discipline or the discharge, such as the government agency would have taken the same action even in the absence of protected speech. So, for example, let's say in that email where I'm saying, I really want to vote for Bob, I don't want to vote for Larry, I also said, and if Larry becomes president, I'm going to shoot him down in the street. I'm going to, get my AK-47 and shoot him in the brain, in the head, and he's going to die. Well, that is pretty good reason for me to be fired, right? Yes, in some sense, some of what I said was constitutionally protected speech, but the part that I'm being fired for is probably threatening the life of a presidential candidate, and I probably should be fired under those circumstances. This is a little bit of information about that Montana statute I've talked about a few times. Again, technically, employment at will doesn't exist in Montana. The statute provides that discharge is wrongful if it's in retaliation for an employee refusing to violate public policy, or if there doesn't exist good cause, which is just another way of saying just cause, or if the employer violated the express provisions of its own written personnel policy. So again, this is the elimination of at-will employment. This is the only state that has eliminated at-will employment. Now, a lot of times you will hear, oh, this is a big deal, Montana's done this. It's really not, because if an employer doesn't comply with the Montana Wrongful Discharge from Employment Act, it has to pay very small damages. It's basically unemployment insurance. So what they've done is they've repackaged unemployment insurance as not as eliminating employment at will, and have augmented it somewhat. It's not exactly like at will employment, not exactly like just unemployment benefits, but it's probably more similar than different. So I don't want to dwell too much on this because, number one, this is just one state that's not very close to us, and it hasn't launched other states doing likewise. So I don't think that this is likely to be a trend. This has existed for a couple of decades at least. I'm not exactly sure what year it began, but it's been around for a while. Okay, so now we're going to talk about managing the discharge process. You've decided, or your client has decided, we are going to dismiss Bob. So now it's just a matter of implementing the decision. How do we go about doing that? And how do you advise your client to accomplish that? Okay, well, first of all, let's just reiterate termination should not be done lightly. If there are other mechanisms that can work, those ought to be carefully considered. Retraining, transferring, demoting, suspending, last chance agreement. All of those things should be reviewed or thought about before you dismiss somebody. Again, for those reasons we talked about before, the cost of rehire or the cost of finding somebody else, training that person, maybe that person won't be any better, the morale implications of the dismissal, and also just the humanity. This is somebody who is out of work. That can be devastating both financially to somebody and also to their self-image. Uh, so it can be a very difficult situation for that person who is dismissed. Sometimes it can make sense to permit an employee to resign in lieu of dismissal. Now, in my opinion, it's important that it be clear to everyone that this is not I guess, a voluntary resignation. That you're not lying to anybody. You're saying, okay, we're letting you resign, but it's in lieu of dismissal. Meaning, if you weren't resigning, you would be dismissed. And so there's not any confusion or ambiguity. Now, it can be advantageous for the employee to choose to resign. For example, he can go to the next job interview and he can say, I resign my employment, and it's not a lie. And hopefully the employer where he resigned would back him up in that. But resigning in lieu of dismissal doesn't mean that that employee can't file for unemployment benefits because, of course, he had no option of continuing his employment. He may or may not be awarded unemployment benefits. That's going to turn on whether he, had a reason, whether he engaged in misconduct related to work or not. But at least he has that possibility. An employer can't legitimately say, well, he's not eligible for unemployment benefits because he resigned. Well, if you tell him you're going to fire him unless he resigns, he's not really resigning. So that can be an option to permit a resignation. There's relatively few downsides to permitting the resignation if that's what the employee wants to do. I have had clients in the past who refused to allow employees to resign because they were so angry at whatever the employee did that they just kind of wanted to, really give it to that employee. It's almost never a wise idea to allow kind of emotions to interfere in that way. I think it makes a lot of sense to allow the employee to resign. On the other hand, if the employee doesn't want to resign, uh, the employee should not be, coaxed or cajoled or pressured to resign. At most it should be offered as an option. And it doesn't have to be offered as an option every time if the employee says, well, could I resign instead? I think a good response is almost always going to be yes, if that's what you want. And if you anticipate that the employee might like that option, you may want to put it on the table for the employee to consider. It's always a good idea before you dismiss to have at least 2 levels of review, the supervisor and 1 level up. And the person 1 level up ideally should be somebody who has an HR background, somebody who can consider the situation from a legal compliance standpoint and decide whether that makes sense or not. Many employers have a policy that says, before you can dismiss an employee with X number of years of service, you need to get this level of review. Maybe you go to a higher level of service, you need to have a higher level of review. When I worked at JCPenney, I probably spent about half of my day reviewing dismissal decisions. Maybe not half, but 2 or 3 hours a day reviewing dismissal decisions. That was a very significant part of my daily work responsibilities. And That's a reasonable, involvement for paralegals and attorneys to have. So sometimes it's someone in the legal department, sometimes it's someone in HR, sometimes it's just a higher level manager. But there ought to be additional review. And part of that is, number one, the supervisor probably doesn't have a lot of sophisticated legal knowledge in this area, or HR knowledge. He or she probably also has, some fairly strong emotions going on. Uh, there's been this situation, this problem, and he or she wants it solved. And so there can be a loss of objectivity, kind of an emotionality in that situation. Having someone a little bit more removed can help that situation get a little bit more clarity on that situation. Now, this, of course, delays acting on it. And if it's a situation where somebody's stolen or from the company, or somebody's, sexually harassed somebody or something along those lines, it could well be appropriate to put that person on some kind of administrative leave until the matter gets resolved. If the decision is to go ahead and to dismiss, then the employee ought to be told the reason why, the reason for the dismissal ought to be clear and unambiguous, that he or she knows this is the reason. We called them, when I was at JCPenney, we called it a reason for dismissal, and it was a form, and it was typically 1 or 2 sentences where we summarized why this person was being dismissed. And again, it's a very common thing with large companies. There were a series of codes. We probably had about 30 codes that we used for various dismissals. So, absences tardies was one code, a theft was one code. And then there was a kind of a catch-all miscellaneous where we'd put kind of the unusual situations, and then that we'd have a description of what happened. Writing that description is a very complex thing to undertake. Let me explain to you the risks of kind of both approaches. So one approach is, let's say the person is being dismissed for theft. And let's say the code for your employer is 17. So you might say, Bob is being dismissed due to code 17, period. And that's your whole reason for dismissal. Or maybe you put the actual word of the dismissal code in there. So that's one extreme, where you're giving no extra information other than the reason, kind of maybe not even presented in a very clear way. The other extreme is you tell the whole story about what happened, and you even document how thorough your investigation was. Those are the two extremes. Let me first of all talk about the first one. The first one, and of course, what you're thinking when you're writing this is you're thinking, how will a jury perceive this? And juries oftentimes see that first one as, wow, you couldn't have bothered to actually put it in English? You used a code? This is a person's livelihood. This person has to go home and explain to his or her wife or husband why there is not going to be any money, and why they may be kicked out of their apartment, and why there won't be any Christmas this year. And you give them a lousy code 17? Wow. Talk about disrespecting somebody, right? And so that's the danger of the reason for dismissal that seemed to have been produced in about 30 seconds. It doesn't seem respectful. It doesn't seem to reflect that the employer spent very much time at all thinking about making this decision. It ticks the jurors off, basically. So the other extreme, the other extreme has two problems with it. One problem is that it can read to be very kind of beat up the employee, where you kind of document everything this employee has ever done wrong, and you kind of put it under the microscope. And it kind of seems like, well, gosh, I mean, you don't need to beat him up. You're firing him. You don't need to, kind of document over the last 20 years, every single time he, you know, did anything slightly wrong. It can look to be piling on. It's bad enough he's being fired. You don't have to just completely take away any, dignity he has in the situation. So by being too kitchen sink-ish, you can tick jurors off in that way. The other risk with the very long reason for dismissal is that if it's very long, you're likely to get something wrong. Uh, you say Larry accused Bob of doing XYZ. Well, in fact, it was Susan. You just got your people backwards. There were so many different people in the story. Or you say that Bob did XYZ on June 14th. It actually was June 15th. And so you start making little errors along those lines or exaggerations. And then the jury starts saying, well, this isn't exactly what happened. What else did they get wrong? Or even if there's a single mistake, maybe we ought to just reinstate Bob. Almost kind of this holding the employer up to this very, very high standard of perfection. Um, so those are the risks of the two extremes. Usually, as a result, you kind of look for something in the middle, something that doesn't go into the specifics, but does clearly state the reason. So a reason for dismissal might go like this, Bob's employment is ending today due to his repeated absences and tardies over the past several weeks. Please review his personnel file for more information about those occurrences, period, something along those lines. You're not, so there's really no specifics, so you can't have really gotten anything wrong. You can't write down the wrong date or anything along those lines. But it's also clear why Bob's being dismissed. And so something kind of in the middle oftentimes works. Now, when it is a controversial dismissal or it's a high ranking person who's being dismissed, or a long service person, typically you're going to go more towards the detailed approach. And that makes sense because you're not going to get your facts wrong. Then you're really going to look at it very, very closely. This is going to be something that you've invested a fair amount of time and energy in. And so under those circumstances, you're going to kind of dot every I and cross every T and really read it carefully to make sure you're striking the right tone. It doesn't seem like you're piling on, and you fact checked everything. So again, the longer the reason for dismissal, probably the more serious the whole circumstances are. Another thing is if you're letting your supervisor write the reason for dismissal, you probably want it to be much more like the first kind, the one that you just kind of quote the code, because that person isn't going to be probably a wordsmith. And he or she probably isn't an expert in what the dangers are of poorly written reasons for dismissal. And so you want more of a cookie cutter approach under those circumstances. But if you're having a sophisticated HR person write it, again, you may be more towards more information, more details. The reason for dismissal should be in writing. It should be prepared before the meeting with the employee, and all of that material should clearly support the reason that this person is being dismissed. The termination should happen in a place where the employee is given some privacy. It should be a confidential meeting. Typically, the employee's supervisor or possibly someone from HR will conduct the meeting. Usually, there's another person from the company's also there so that there's somebody, so we don't get into a he said, she said situation. There's another person from the company who can present that. If it is a union situation, then the employee will likely have the union steward be present for this. This meeting shouldn't be a long meeting. There's nothing to debate. There's nothing to discuss. You've already had the meeting where you've heard the employee's version of what happened. This is just telling the employee what the decision is. And oftentimes there's the need to, get a credit card back from the employee or keys to the office from the employee or, laptop or, whatever the things are. So there's some administrative matters. And then there will typically be a discussion about, what the final paycheck will be like. Is there going to be kind of vacation pay in that? Also discussion about COBRA benefits. So there's some administrative matters to talk about, but usually these meetings are over in 10, 15 minutes. If it lasts 30 minutes, that's a long, long meeting. It's not helpful for the employee or the employer to drag this out. After the meeting happens, ideally you want to give the employee an opportunity to leave the situation with as much dignity and as much privacy as possible. Sometimes they want to leave right away, which is what the employer should permit. Sometimes they want to pack up their office right then. Again, that's a reasonable approach. Usually it's good to have these meetings at the end of the day. So if the employee does want to pack up his or her office, there won't be other people kind of going by and saying, "Hey, what are you doing? What's going on?" Again, that's not a situation that's helpful for the employee or the employer. It's best to allow the employee to take care of his or her affairs and then to be able to do that in a rather confidential manner. If the employee doesn't want to take care of it right then the employer should pack up the stuff. Again, ideally when no one else is around, and provide for a time that the employee can come to get his box of stuff. And you may even want to put it in a place where the employee doesn't have to go back and see his former coworkers. Maybe there's a particular location that might be a little bit in the place of employment, might be a little bit easier for that employee to collect his things in that situation. Obviously, if an employee is dismissed under these circumstances, there's going to be talk in the workplace. Why is Bobby not here? I saw his name is not on his cubicle anymore. What's going on? So there's going to be questions. Generally, what an employer ought to do in that situation is say, Bob is no longer employed here. I'm afraid I can't give any additional information. Sally, you're going to be taking over this part of Bob's job. Teresa, you're going to be taking over this part. Larry, you'll be doing this part. I expect in the next week or so, we'll be posting for someone to fulfill that position, and I'll keep you posted as we know more and kind of move on from that perspective. Usually employees are going to figure out what's going on and recognize that the employer is trying to handle this matter in a professional and respectful way, and they may talk amongst themselves about what happened to Bob, but they probably won't bother you too much. But if the manager does get bothered, he just kind of needs to continue with that explanation and not go into any more specifics. Employers do need to pay final pay quickly. We have a statute in Texas, we covered in another module, that says that whenever an employee is discharged involuntarily, they need to get their final paycheck within 6 calendar days of the dismissal. So that may be prior to the usual dismissal date. And so as a result, you may need to expedite the issuance of the check. If that is not possible, then you may need to plan your dismissal so that it's going to fall within 6 days of when that normal check would issue. And if it's a voluntary dismissal, there isn't the need for the expedited check. There are other states like California that requires that the person be paid on the day of dismissal. So the 6-day rule is not a universal situation. Usually employees, even employees who've been dismissed, are going to be eligible for COBRA benefits. We talk about what COBRA benefits are in a different module, but these again are the mechanism by which an employee can continue his health insurance after he is no longer employed. It is true that COBRA does allow employers to exclude employees who were discharged for gross misconduct. Again, very serious misconduct. In my experience, employers rarely take advantage of that, and they basically offer COBRA benefits to all employees, even employees who were dismissed. But certainly, an employer could have a different position on that and may choose not to offer it. Since it really doesn't cost the employer really any money to offer the COBRA benefits, it seems a little bit kind of salt in the wound to exclude the employee under those circumstances. But again, sometimes emotions run high, and sometimes employers don't want to even extend COBRA benefits to employees with whom they are very angry. So sometimes a dismissal seems like it's absolutely the right thing to do, but it comes with legal risks. Maybe this is the only employee in this particular unit of a particular religion or race or gender or age. And so there's real concerns that even though the employer feels it was the right decision, there are risks associated with that. And so one thing that employers often consider in that situation is, do we want to give some kind of payment in exchange for getting a release to mean that we won't face any kind of lawsuit as a result of this matter? It can be a relatively inexpensive way of avoiding a lawsuit, which can be very disruptive of the work environment, can be very expensive, and could potentially result in that employee being reinstated. There are a lot of requirements for most releases in this area. Basically, the laws of contracts apply unless the person is over the age of 40. And if a person who you are dismissing is over the age of 40, they potentially have an Age Discrimination and Employment Act claim. They could also have, a race, religion, uh, disability, or any of the other categories of claims as well. But if you want to release the age claim, you have to have some very specific requirements. So just the general requirements of contract law aren't going to work for an age discrimination type claim. Let's look at what the requirements are under the Older Workers Benefit Protection Act, which is an amendment to the Age Discrimination Employment Act. We've talked about this in another module, but let's just do a little bit of a refresher here. First of all, the waivers must be plainly worded. They have to be written so that somebody who isn't an attorney can read it and understand it. And they have to specifically mention the ADEA, and not just by initials, but the full name. And they have to suggest that the employee talk to an attorney before accepting. There has to be legal consideration, meaning typically money is going to be usually what the employee is getting out of this, but it doesn't have to be money, but that's going to be the consideration or the benefit to the employee that the employee gets 99.9% of the time. The employee has to be given 21 days to consider it. And again, we're talking about individual terminations, not group terminations. But if it is a group termination, they have to have 45 days to get it. And once the employee returns it, he gets 7 days to change his or her mind. So in theory, if the person waited the 21st day, with the 7-day revocation period, the person has 28 days to consider the whole deal. Now, if he signs the release, say on the 3rd day, then the 7 days start on that 3rd day, so we'd only get 10 days in that situation. And we'll talk more about the group termination situation in another module. So those 45 days we'll revisit, and we'll talk about at that time why the group termination action has some different requirements. Employees can waive claims, can only waive claims that arose prior to the date of the waiver. So let's say that you are dismissing Bob on June 4th. Well, you can release it, Bob can release any claim from June 4th back in time. So let's say that Bob agrees to it, Bob releases his claim, and then on September 13th, a few weeks later, the employer gets a reference call on Bob, and the employer says, "Oh no, I'd never rehire Bob. He stole from us." Well, Bob could then file a lawsuit for defamation. He hasn't waived that claim because it didn't happen on June 4th or before June 4th. He didn't have a crystal ball. He didn't know what the employer was going to do. And so you can't ever waive claims for things that haven't happened yet. So here's some summary of things to help your client be aware of as it navigates through the dismissal of an individual employee. Okay, very likely the employee is employed at will, but it has very real limitations in terms of actually how it should work. As a result, an employer is very smart to apply a good cause or just cause standard, even when the employee is at will. Employers should look very carefully at all of the circumstances, make sure they have a clear, full, complete understanding of what happened and why it happened, and consider the various legal claims that the employee could make, and do all of that before a decision is made, and certainly before it's communicated. When the decision is made to dismiss, care should be spent in how to implement the decision so that the employee's situation is handled privately, respectfully, sensitively, so that the employee can leave that situation and move on to the next stage in his or her life. And of course, it's a smart idea in the right case to consider the possibility of a waiver, some kind of severance package that will allow the employee to uh, uh, get some money, but at the same time, no longer be able to sue the employer. I hope that this presentation has been helpful for you. As always, if you have questions about the material, please feel free to pop into my office hours. I thank you for your attention and have a wonderful day. Take care.